Hey everyone, yesterday on Instagram I told you that we would be breaking down this International Commission of Jurists report that was essentially, in its essence, advocating for the removal of age of consent. And so I want to go back and provide the entire context of the report and other things that were said to inform the opinion that I made. Now, who am I? For those of you who don't know me, my name's Nick McKinley. I'm the founder and CEO of DeliverFund, and DeliverFund is a counter-human trafficking organization. We build technology that protects society from human traffickers, and as a second order byproduct of doing that, we sit on the largest and cleanest human trafficking database on the planet. So our opinions are informed by the data we have and the analysis that we've done on the data we have, as well as our analysts and the work that we do with law enforcement, with service providers, both in the United States and abroad. So the function here is to take what we have learned about the fight against human trafficking and child exploitation and actually help you see this report through that light. For those of you who don't understand what report we're talking about, or you might have just stumbled upon this, we're talking about a report from the International Commission of Jurists. Now, in the modern media and the popular media, it's being portrayed as a UN report. The International Commission of Jurists and the UN are two different things, although they are closely linked, but this is not a UN report. This is a report from the International Commission of Jurists, and it was released in March of this year, 2023, and it is titled Criminal Law Prescribing Conduct Associated with Sex, Reproduction, Drug Use, HIV, Homelessness, and Poverty. And the beginning title is The 8 March Principles for a Human Rights-Based Approach. So this is the International Commission of Jurists is a bunch of international judges from various countries who have they were obviously, I would say, due to the lack of opposing opinions in this finding. These judges were very clearly all selected because they all had the same ideological views. Because the ideological views that are in this document are extreme, to say the least. I mean, even the most liberal reading of this document and giving the most grace to the jurists who wrote it, it still paints a pretty abhorrent picture. Now, I have nothing against the International Commission of Jurists. I don't know anybody there. I am not a lawyer, but you don't need a lawyer to read plain English. And this is written in plain English. It is not written in some legalese. And the fact that the arguments that people make that you have to be a lawyer in order to actually understand plain English and policy and recommendations that people are making, and saying that this plain English is being taken out of context is absolutely ridiculous. A mentor of mine once told me that if you take a text out of context, you get conned. And so I'm actually going to give the context of this entire document. I recommend you go read it for yourself. It's not that long, but let's start walking through it. Now, when you look at the foreword of the document, one of the first things that stands out that I think is key to providing context in the way that I'm thinking about this document and the way that we're thinking about this document at DeliverFund is it says on page 2, and I quote, the principles, and is speaking about the principles that are outlined in this document. The principles aim to be practically useful to the widest range of stakeholders. So remember that, because some of the counter arguments to my views on this document are that, well, they're not saying that adults can't have sex with children. They're not saying that. Well, it very clearly says that it's to be practically useful to the widest range of stakeholders, which includes everybody in law enforcement and in law generally. And let's not forget, it's politicians who make law. So therefore, they are stakeholders in this document. The next statement I want to bring attention to is the beginning of the second paragraph of page 2, where it says the principles, meaning the principles in this document, are based on general principles of criminal law and international human rights law and standards. Now, we can all agree that there is such a thing as international human rights standards, but there is no such thing as international law. That does not exist. If there is such a thing as international law, then why don't one of the lawyers or judges who wrote this go arrest members of the Taliban for beheading little girls who are just trying to get an education? That is clearly against, or they're doing that is clearly against an international standard, but there's no such thing as international law. There are only laws that states agree to equally uphold usually through treaties. But there's no such thing as international law. So don't be confused by the modern media where it's saying that, well, the UN has no jurisdiction in the United States of America. In fact, were it not for the United States of America, the UN would be a shell of what it currently is. Also, the International Commission of Jurists does not work in the United States of America, and thank God after reading this. So within the introduction paragraph on page 5, I want to read a paragraph that I think sheds some interesting light on this whole document. It says, quote, "While retribution, deterrence, incapacitation, and rehabilitation are generally considered to be its meaning the law enforcement community, its main purposes, criminal law may also perform an expressive function through public condemnation of certain conduct seen as deserving reprobation and punishment. The desire to harness this expressive function is a critical factor contributing to the proliferation of criminal law." Now, why is that important? Because according to that statement in this document, it is stating that public condemnation of certain conduct is seen as deserving of reprobation and punishment. That is absolutely 100% true here in the United States of America. We are not interested in 40-year-old men being able to have sex with a 12-year-old child as long as that 12-year-old child is consenting. And that is what this whole document is arguing for. So yes, the criminal law is an expressive function. That is true. And we want it to continue to be an expressive function of our values, which universally are that children should be protected and not sexualized. If we move into page 6, now this is why I think there's a lot of confusion in the media that this is some type of UN report. You know, again, we explained that the UN and the ICJ have a close relationship, but that does not make one the other. And it quotes the UN a lot as if the UN is a body of authority that applies to its work, but the UN has no jurisdiction. The UN is not an authoritative body when it comes to law. On page 6, third paragraph down, it says, and I quote, "In recent years, the UN Secretary General, the Office of the High Commissioner for Human Rights, and global and regional human rights mechanisms, bodies, and experts, as well as national courts, legislatures, and domestic human rights institutions, have expressed concern about the harmful human rights impact of criminal laws proscribing conduct associated with," and it lists many different things, but one of those is consensual sexual activity. So that's a key thing that we want to focus on. It keeps using the word consensual, but one of the things we'll discuss later is what does that actually mean and who gets to decide what that means. Moving on to page 7 at the beginning, the document says, and I quote, "Time and again, criminal law provisions enshrining discriminatory proscriptions may be rooted in, embody, and codify unequal power relations that, in turn, are often the legacy of colonial, xenophobic, racist, sexist, classist, ableist, cultural, religious, social, political, economic, or other power dynamics." So it's very specifically saying that it's trying to reduce any discrimination based on an unequal power dynamic. And I think that's a great thing. Let's continue that. However, there is no more unequal dynamic than between an adult and a child. Or in this case, as the document describes, an adolescent. And we'll get into what the word adolescent means. Moreover, and this is the page 7 continuing, moreover, substantive and procedural criminal law may, whether or not by design, effectively incorporate elements of discrimination embedded in perceived gender roles and patriarchal heteronormative power relations between women and men and in other historical distinctions founded upon prohibited discrimination grounds. So it doesn't want to discriminate. We can all get behind that. Ultimately, criminalization in law and application is the product of political decisions made in the service of existing relations of power that often detrimentally affect persons belonging to already marginalized or disadvantaged groups. How is there a more disadvantaged group than children? Children is the most disadvantaged group by definition. That is why, as a parent, I am allowed to have custody of my children. I am allowed to make decisions for my children because they are the most disadvantaged, because they do not have the ability to make those decisions for themselves. That provides a lot of context on what the document is trying to convey. If we continue at the end of page 7, it says, quote, in particular, General Parts 1 and 2, which is what we just discussed around what is criminalization, may assist in considering the compliance of other criminal offenses, including overbroad criminal provisions used to target conduct addressed in these principles. So what that will do is you will see the principles later on will actually talk about the removal of consent age and the removal and essentially making pimping, and there's no such thing as a pimp. Human trafficking is the correct term, making human trafficking legal. One of the things that was very interesting is on page 8, where it talks about the particular what it calls the overbroad criminal provisions used to target conduct addressed in these principles. That paragraph continues on to the first sentence of page 8, where it says, sexual speak and certain kinds of pornography. There's only, to my knowledge, 2 types of pornography that are illegal. And it's pornography where there are crimes committed as part of the pornographic material. Obviously, the biggest one of those is the child sexual exploitive material, right? Or what people usually refer to as child pornography. That is, to my knowledge, one of the only types of pornography that is illegal, and yet they're addressing certain kinds of pornography. So where are they going with this? To just say certain kinds of pornography, like they need to be much more specific. And I'm not attacking the ICJ here. I mean, most of what they stand for and agree with, I would say that personally I don't, but I'm not attacking them. What I'm trying to do here is show how dangerous a document like this is, and how the criminals, the human traffickers, the child pornographers, the child rapists in our society will use a document like this to justify their own actions. Let's get into the meat of the actual document and what it is that I'm really talking about here. And we get into page 12, 3 paragraphs down, quote, noting that at a minimum, consent, so it's talking about, the consent, and it's not implied yet, but it's just the concept of consent, sets the boundary between justifiable and unjustifiable state interference in certain conduct and context, and that ascertaining the presence or absence of consent is a matter of evidence and factual investigation with due regard to the strictures of the law and one's capacity to consent. So within its own document, it just said that we need to take into account one's capacity to consent. So that's going to become a very important point of argument here. Reading from the document, acknowledging that the absence of consent may give rise to criminal liability for the conduct concerned, emphasizing that with respect to the application of criminal law in connection with consent, international human rights law, which we already discussed, does not exist, requires paying attention to, and it lists some things, but then it very specifically says, adolescents' evolving capacity to consent in certain contexts. In fact, even if not in law, when they are below the prescribed minimum age of consent in domestic law. That is critically important because this is the first shot that this document fires at age of consent laws. I'll read that again. Emphasizing that with respect to the application of criminal law in connection with consent and taking into account adolescents' evolving capacity to consent in certain contexts. In fact, even if not in law, they are below the prescribed minimum age of consent in domestic law. So it just said that even if they are below the prescribed minimum age, that's okay, which is advocating for the removal of consent laws. So now we'll get into part one, where it starts defining what the basic principles of criminal law are. And I want to specifically, most of these are very, very straightforward and things that we all agree on, but let's focus on point two, where it says it's the harm principle, and it says criminal law may only prescribe conduct that inflicts or threatens substantial harm to the fundamental rights and freedoms of others. Well, we know that sexual contact with a minor and that sexual contact at increasingly young ages causes harm. We know that. It's a statement of fact. So I agree with that. Criminal law should only prescribe or prescribe conduct that inflicts or threatens substantial harm to the fundamental rights and freedoms of others. The problem here is who gets to decide what substantial harm is? Who gets to decide what the fundamental rights and freedoms are? So this is a problem when it comes to thinking about this through the lens of human trafficking and through child exploitation. And then it also goes on to say in Principle 4 that there's a voluntary act requirement. So it says, no one may be held liable for a criminal offense unless that person has engaged in a voluntary act or omission as defined in that offense. Criminal liability may not be based on thoughts, intentions, beliefs, or status alone. So that's an incredibly important point here, is that it says criminal liability may not be based on thoughts. I agree. We can't be, there's no such thing as thought police, beliefs or status, but it says intentions. So why is that important for the fight against human trafficking and the fight against child exploitation? Because oftentimes law enforcement officers, they will act like they're children online. And these are sting operations. We've all seen TV shows around them. And they will set up as if they are a child, and they will lure child predators in. Now, when that child predator shows up, the child predator doesn't actually commit a crime because there's no child for them to have sex with. So there's no actual crime committed. So it is the intent, it is the fact that they very clearly had the intent to have sex with a child. They very clearly had the intent to traffic another person that lands them in jail. So based on what ICJ is saying here, all of those law enforcement operations, we would no longer be able to do. Law enforcement would lose one of the biggest tools they have for identifying the most disgusting people among us. That's a problem that we can't have. Now we get into the meat of the document, which starts on page 20, and I'm specifically going to refer to principles 14 and 16 and 17 when it comes to this document. And this is where it gets into actually discussing commercial sex, starting to discuss consensual sexual activity and age of consent and sex work. So within the principles, it says consensual sexual activities, including in such context as sex outside marriage, same-sex marriage relations, adolescent sexual activity, and sex work. So there's the first use of the word adolescent. So we know that ICJ or IJC is closely aligned with the UN. We know that. So let's use UNICEF, right? The UN Children's Organization. Let's use their definition of adolescence. According to, and this is at data.unicef.org, go look it up for yourself. They say, quote, an adolescent is defined by the United Nations as those between the ages of 10 and 19. 10 and 19. So we are, according to their own references that they are citing, we are talking about children as young as 10 years old here. So all of the arguments that are, well, this is a document about, allowing pedophiles to have sex with 5-year-olds, like, let's just remove all of those arguments. So the smallest age here that this document is talking about is 10 years old. And that's according to the organizations that they are citing. If we look at thelawdictionary.org, they state, quote, that adolescence is that age which follows puberty and precedes the age of majority. It commences for males at 14 and for females at 12 years completed and continues until 21 years complete. So we know, let's just say that we are talking about, let's find the mean here between the two, and instead of saying as young as 10, we'll say that we're talking about females as young as 12. We'll use that definition. So they use the word adolescent. They're the ones that put it in it, and they very specifically said adolescent sexual activity and sex work. Why is the term sex work in the same sentence as adolescent sexual activity? That requires some explanation. I can find no reason why there should be the word adolescence, sexual activity, and sex work in the same sentence. It makes absolutely no sense. It goes on to say that no one may be held criminally liable for providing assistance to another to enable them to exercise their rights to sexual and reproductive health, unless there is coercion, force, or lack of free and informed decision-making in relation to the exercise of such rights. Tell me how a 12-year-old makes free and informed decisions. A 12-year-old, by definition, is a child. They are an adolescent. They do not have the life experience or education to make free and informed decisions, which is why their parents make decisions for them. So here it says that no one may be held criminally liable for providing assistance to another to enable them to exercise their rights to sexual and reproductive health. So by this, as I read this, a 12-year-old could say, I want to go have sex with that 40-year-old person, and somebody could facilitate that, and you'll see later they could actually get paid to facilitate that. And according to IJC, there should be no criminal liability for that. Another piece that IJC is protecting here is parents, guardians, carers, or other persons who enable or assist children or people in their care, including persons with disabilities, to exercise their sexual and reproductive rights, including by procuring sexual and reproductive health services, goods, or information. They may not be held criminally liable unless they've engaged in coercion, force, fraud, or there was a lack of free and informed decision-making. So again, they're now protecting what we call bad parents. So bad parents in the human trafficking space are parents who, for any number of purposes, psychological issues to drug addiction to a myriad of other reasons, will sell their own children. And they will often convince their own children that this is in their best interest. So they're not forcing their children, even though they are the parent. So anytime a parent tells a child to do something, it's essentially an article of force. But these parents will convince their children to go perform sexual services, and the children think that they're doing the right thing by making their parents happy. We have a staff member at DeliverFund who experienced that and is very vocal and writes books about it, and you can find videos about that on our YouTube channel. Just search at DeliverFund. Let's move on to Principle 16. This is the screenshot that I posted yesterday. So now I've provided all of the context to back up why I made the post yesterday that I did. And I provided a screenshot, and people said, well, that's not what it said. Well, go back and read the entire document, and you'll see that's exactly what it says when in Principle 16, consensual sexual conduct, it says, and I quote, consensual sexual conduct, irrespective of the type of sexual activity and the sex, gender, sexual orientation, gender identity, or gender expression of the people involved or their marital status, may not be criminalized in any circumstances. So it is very much talking about consensual sex. It just defined that. You heard it with your own ears. Go read it yourself. That's on page 22. The second paragraph that says, with respect to the enforcement of criminal law, any prescribed minimum age of consent to sex must be applied in a non-discriminatory manner. That is a problem, because in the United States at least, and I think many westernized countries, we apply the laws in a discriminatory manner in regards to age. As an example, if you have two 17-year-olds who are dating and who are sexually involved, and one of those 17-year-olds turns 18, it used to not be the case, but is currently the case, where prosecutors do not charge that 18-year-old because they are considered an adult, and the 17-year-old is still considered an adolescent. They're still considered a child. We don't like we apply the law in a discriminatory manner as it applies to age. So under these recommendations, we would no longer be able to do that, which means that we either have to charge the 18-year-old, which is wrong and going to ruin their life, or we have to not charge anybody in those circumstances. And which one do you think this type of organization is going to fall on? They're very clearly moving towards the we can't charge anybody for that. If we charge anybody, we have to charge everybody. And if we don't charge one person because we choose to exercise some grace in our jurisprudence, well, we can't do that. Then that means that we have to exercise grace to everybody in our jurisprudence. It goes on to say, moreover, sexual conduct involving persons below the domestically prescribed minimum age of consent to sex may be consensual in fact, if not in law. Sure, but who gets to decide that? Does the 12-year-old get to decide that they really wanted to sleep with that 40-year-old man? Because those are the types of cases that we see at DeliverFund, that our analysts see all the time. Those are the types of cases that the brave men and women in the International Crimes Against Children offices around the United States and around the world see all the time. And when they talk to the children usually say, yeah, so-and-so convinced me to do that. That's a parent or an authority figure. So oftentimes they think they're doing something that they're consenting to because they don't understand the actual consequences. So that's why we say they don't have the ability to consent. It goes on to say that, moreover, sexual conduct involving persons below the domestically prescribed minimum age of consent to sex may be consensual in fact, if not in law, and in this context, the enforcement of criminal law should reflect the rights and capacity of persons under 18 years of age to make decisions about engaging in consensual sexual conduct and their right to be heard in matters concerning them. When my child punches his sister because he is a child and man is inherently fallen and does these types of things, I am supposed to hear him and not necessarily, according to them, I'm not supposed to punish him for punching his sister because he has a right to be heard in the matters concerning him. Instead, I don't care what his excuse is. He has no right to punch his sister and is never allowed to punch his sister. You see my point here. The state is essentially the enforcer of the rules, the parents of the populace. And so when we say that a 12-year-old has a right to be heard on whether or not they wanted to have sex with that 40-year-old man because they were buying them nice gifts and giving them money and things, that's absolutely ridiculous to think that the 12-year-old has any idea what the long-term, lifelong consequences are to her. And the ICJ is very clearly advocating for that. It goes on to say that pursuant to their evolving capacities and progressive autonomy, persons under 18 years of age should participate in decisions affecting them with due regard to their age, maturity, and best interests, and with specific attention to non-discrimination guarantees. Well, I would say that most 12-year-olds would tell you that it was in their best interest to allow them to drive the car to the mall. But we don't allow them to do that because we know it is not in their best interest. So the whole reason why we do not allow children to say what is in their best interest and we make those decisions for them, obviously with their input, is because we know that children do not know what's in their own best interest. Otherwise, turn your company over to a 16-year-old child. Turn your company over to a 12-year-old child. If they know it's in their best interest and they can make those types of decisions, then and they can make these types of life-altering decisions, then what other decisions can't they make? So that's where when it talks about consensual sexual conduct, it very specifically is talking about age of consent. And when it refers to age, we know it's not talking about 17 years old here. It very specifically said beforehand adolescence, which we know is as young as 10, but we're saying that the bottom of that is 12 for the purposes of this conversation. Now, here's where it gets extremely concerning. The worst stuff we haven't even talked about that yet. Here's where it gets the most concerning and where it is essentially advocating for the legalization, not just of prostitution and sex work, but of human trafficking. Now, what is human trafficking? Human trafficking is when somebody is, under the law, forced, defrauded, or coerced to provide a service for the economic benefit of somebody else. It's an exchange of value for sex where the other person doesn't want to do it and is being forced to do it, being defrauded into doing it, or being coerced into doing it. So that is the most reducible definition of human trafficking that we can have. And the labor, the service being provided, doesn't matter if it's commercial sex in nature or making bricks, right? It's all forced labor. So in Principle 17, I'm on page 23. Principle 17 is sex work. The exchange of sexual services between consenting adults for money, goods, or services, and communication with one another about, advertising an offer for, or sharing premises with another for the purposes of exchanging sexual services between consenting adults for money, goods, or services, whether in a public or private place, may not be criminalized absent coercion, force, abuse of authority, or fraud. So let's break that one down. The exchange, going back to the top, the exchange of sexual services between consenting adults for money, right? So basically it's saying that should not be criminalized. The data on the legalization of sex work is very clear. The best way to have an increase in human trafficking is to legalize sex work. That is a statement of fact, and that is a hill I will die on. However, one of the things that is the bigger problem here is that it says that exchanging sexual services between consenting adults for goods or services. What we need to talk about is whether or not people have choices. And it gets into that in the next paragraph where it says, criminal law may not proscribe the conduct of third parties who, directly or indirectly, for receipt of a financial or material benefit under fair conditions without coercion, force, abuse of authority, or fraud, facilitate, manage, organize, communicate with another, advertise, provide information about, provide or rent premises for the purposes of the exchange of sexual services between consenting adults for money, goods, or services. So what that is saying is that if somebody says, hey, young teenage runaway, homeless girl, I know you're in Detroit and I know it's 10 below zero and you might freeze to death tonight, but come on over to my house and if you have sex with me, I'll give you a place to stay. How is that a choice for that young girl? According to this document, the person who makes that or who makes that offer to that young girl cannot be prosecuted because it's consenting. Well, oftentimes people who engage in commercial sex activities and people who are trafficked, they don't really have much of a choice. They often know that the chances of them being trafficked are high, but they think it's worth the risk because where they're coming from, the poverty they're coming from, the refugee status they're coming from, the war they're fleeing, the famine they're fleeing, the floods they're fleeing, the abusive father that they ran away from. They know that taking a risk of being trafficked is better than going back to what they had. So, is that really a choice? So when you combine the removal of consent, or in any case, let's give ICJ or IJC the most grace here, and we can say that they were just trying to reduce the age of consent to adolescence. Okay, so they're reducing it down to 12. In their arguments, the 12-year-old can consent to provide sex to a 40-year-old or older in return for a place to sleep. That is absolutely unacceptable, and that is not the society that we want to live in. And that only further will encourage human trafficking. So that's why I took the stance that I did on this ICJ report. I would be happy to debate this with any of these authors, endorsers, or supporters on why this is a good idea and where I got this wrong. I don't think I did get it wrong. Consulted with a number of lawyers over looking this over and understand the arguments that people are making, but at the end of the day, we have to take a stance against right and wrong. And if we cannot rally around what is right and what is wrong with regards to children, especially when it comes to anything sexualized, then our society is absolutely doomed. We'll put a link in the comments and a link in the bio, depending on what platform you're watching this on, to the actual webpage where you can download this report for yourself and look at it. Thanks for listening to me rant about this extremely important topic. And if you agree with me, I hope you will make your voice very loud and help the International Commission of Jurists understand that this is not the type of documentation that they should be releasing to the world, and that they need to do some real soul searching and character digging to see if this is really the world that they want to live in. Thank you.